What we are talking about today is estate planning reimagined. My name is Attorney Veronica McClendon, and I will be presenting this information for you today. I like to call it estate planning reimagined because a lot of times people see estate planning as something that they really don't want to do, but they know they have to do, so they just do it to get it out the way. Or they see estate planning as something that makes them feel sad because they're like, man, it's making me think about when I'm going to die, and I don't want to think about that. And I like to help people to turn it on its head so that it's not something that we're dreading, it's not something that we feel is a burden, but it's something that we actually look forward to and consider to be a part of our lives on a daily basis. Because really, estate planning is a way to honor like the investments in your life that you're making every day. It's a way to make what you're putting in place with your hard work and with the energy you're putting into things with your time. It's a way for you to continue that legacy so that it doesn't just stop with you. So we're going to get into it. So, about my firm is McClendon Law and Consulting, and we provide heirs property, estate planning, and probate legal services to help farmers, landowners, and other legacy driven individuals build wealth, increase income, and secure their legacies. And so, for me, it's not, we don't just work with people who want to get a will done or people who want to get a trust done. We work with people who actually are desiring to leave a legacy, who want to allow what they are putting out into the world to continue beyond their lifetime. So they have a story that they're writing as they live their lives, and they want that story to continue even after they're gone. So that's what we do. We work with families and individuals who are desiring to accomplish that for themselves. So we'll get into estate planning. So there's a slide that I used to have that I took out, and I thought I want to talk about it a little bit. Again, like I said, estate planning is something that a lot of people dread and is not something that they look forward to. But the way that I view estate planning is that it's a way for you to look at your life and decide, am I on the path that I want to be on? If you are on my email list, you probably got an email from me today that said, make a list before you die. Don't Make sure you complete your list before you die. And that came out of this conversation that I had with one of my coaches where he said, I want you to sit down during this time where everybody's kind of pausing and taking a break with the holidays. I want you to take some time out and reflect upon your life, reflect upon what you've been able to accomplish, and then think about what do you want to accomplish before you die, because that's really what it's all about. Like, a lot of us want to live a long healthy life, but why? Like, why do we want to keep living unless we have something that we're living for? And it's easy to get caught up in the day to day and just forget that we're actually doing this for a reason. And so this gives you an opportunity to pause, reflect, and to think, why am I living this life? Why am I doing the things I do? Am I doing the things that actually mean something to me? We can get up, getting a job, going to work, and just doing the day to day things. And if you really think about it, it doesn't mean anything to you. So we get to pivot. We get to say, I want to do something different. And I like to see estate planning as a way to help guide that conversation, because you're thinking, I'm looking toward the end of my life. What do I want to leave to the people I love? Who do I want to leave it to? In what way do I want to leave it to them? Am I on track, or do I need to make some adjustments so that I will be where I would want to be at the end of my life? And of course, none of us have a crystal ball. We don't know exactly what it's going to look like or the timeline or anything like that. But we can put our best effort toward making sure that whatever time we have is meaningful to us and to the people we care about, to the communities that we care about. So that is the framework I want you to come into this estate planning conversation with. We're not just learning how to do a will, we're learning how do we put the tools in place so that the legacy that we are building and creating every day can be transitioned to the next generation in the way that we want it to be transitioned to them. So now, the nuts and bolts. What is an estate plan? We got an estate planning webinar. We need to know what estate planning is. So first, before we can know what estate planning is, we have to know what is an estate. And I define it as all of the money and property that a person owns, particularly at the time of their death. Excuse me. So, we all have heard the state of Aretha Franklin, the state of Michael Jackson, the state of James Brown. That estate is the entity that holds all money and property that they owned at the time of their death. And with a lot of people I just mentioned, their assets continue to grow because they had so many assets, their assets were so valuable that even though at the time of their death, it was at one point, as time has gone on, the value of their estates increase. And that could be you too. If you set it up properly, that could be you too. It's not just for the rich and the famous. It could be for any of us if we set things up properly. But it also includes, which I did not put on this list, like your legal obligations. So if you are, while you're living, you have certain legal obligations. If you hurt somebody, then you might be subject to some kind of a personal injury lawsuit. If you get in a car accident or something like that, someone gets injured, you are responsible for that injury. After we die, those legal responsibilities can still continue. So if someone caused a car accident, at the time of their death, and then another person was injured, someone could sue your estate to say, hey, I know that this person is gone, but the estate that they left behind is still here. And I want to make sure that my claim is paid out of their estate before you give the stuff to their family. So that is an estate as well. Things, well, that can go into your estate, legal obligations, and also legal rights, things that you're entitled to. Again, in a similar way, I've represented estates where the person has died because of an accident, or they were entitled to receive a settlement and they ended up dying before they received their settlement. A lot of times we will have an estate created, opened up for them through the probate courts so that there will be a legal representative to represent their interest in that claim. So their family can benefit from the lawsuit that in a sense is vindicating the death of this person. Or there might be other legal obligations that might be at play that don't have anything to do with an accident or an injury, but all of those things are in a person's estate. So it's what you have in money, property, and then also legal rights and responsibilities, any entitlements. Those kind of things are going to be part of your estate. And so, as you can imagine, all that stuff I just talked about, you might be like, whoa, well, I never thought about that. Well, that's why we create an estate plan, because then we can provide written instructions for how a person's money and property is going to be distributed after they die. We can create a plan for caring for and providing for minor children or other people who are dependent on us. We can create a plan for them so that they can continue to receive the care and the provision that they need, even if we're not able to provide it. We also can plan for healthcare and financial decisions for us while we're still living, but we're unable to handle our own affairs. So you may have seen this with a loved one who may have experienced dementia, or they may have experienced some kind of a injury, and now they're no longer able to handle their own legal affairs. And so, in that sense, they may need someone else to represent their legal interest. So, these are all the things that we can create an estate plan for. And again, the things I just talked about, not only property, real estate, things like that, it could also be that you have a plan for if something happens to me and I'm injured and my death results as comes about as a result of that injury. I could have a plan for having a representative for my estate. All of these things are part of your estate plan. And we're going to talk a little bit more about how do you create this estate plan. But just generally speaking, this is how we define an estate in an estate plan. Y'all let me know if y'all have questions. Like put them in the chat if anything comes up that y'all need me to answer for you as we are going through this. So estate planning, we just talked generally about it. It is passing on your personal assets. It's a plan for passing on your personal assets, planning for in the event of incapacity if you're not able to handle your own legal business or medical decisions, or if you are in a position where you are not able to maintain your personal needs on a day-to-day basis, you can create a plan so that you are in the driver's seat about how things go instead of it being other people making decisions about what happens to you or your property after you're gone, or even if you became disabled and unable to handle things on your own. Come on, slides. Click. Okay. If you are a land or a business owner, your plan may involve a bit more. You may have business assets that you need to plan for. You may have a business operation that you need to have a plan for. You may have some know-how, things that you know how to do, you know where to do, you know what to do, but other people may not know unless you put it in some kind of a written plan. So if you're a business owner or a landowner, you need a succession plan in addition to your estate plan. So now we'll talk about some components of estate planning, just general components, things that would go in a typical estate plan. So most of us have heard about wills and trusts. You may have heard of business entity like an LLC or LLP. I know someone mentioned that in the chat as a topic that they want to get more information on. You may have advanced directive for healthcare, which is where you get to name someone who will represent your medical interests, who can make medical decisions for you if you're not able to make medical decisions for yourself. They can authorize treatments, they can decline treatments, all on your behalf if you are unable to do that yourself. Financial power of attorney, this is a person who makes financial decisions for you. And then if you're not able to, they can make financial decisions for you. They can sign off on legal things on your behalf. Estate planning also includes planning for life insurance and other benefits. I I have a lot of different presentations, and sometimes I don't know which one I pulled out for the thing today. So I don't know if I will end up talking about life insurance and other benefits, but in case I don't, I'll go ahead and say one thing that is a big issue when it comes to life insurance is when people leave have the beneficiaries, they name like a person who is a minor. That means they're under the age of 18, or they name a person with a disability as their beneficiary. And I know that we want to take care of those people that we love, but they would not legally be able to manage things that we leave to them because of their age or their level of mental capacity. So instead of us leaving the property to them directly as a beneficiary, we might want to name a custodian who can receive the assets on their behalf and manage it for them. Or we might name a trustee. If we create a trust, we can have a trust that's created specifically for that minor child or that disabled family member to make sure that their property goes to them in a trust instead of to them directly. And also, we want to make sure that we might want to make funeral arrangements. Go ahead and make prepayments on our funeral plans. Go ahead and plan out certain details so that that's one less thing that your family is having to think about when they're grieving and stressed, and who knows what's going on with them at that time. It's a way for you to take that burden off of them so that they're not having to deal with it themselves. So let's get in a little more details about wills. But while I do that, I do want to just check in, make sure there's no questions that y'all need to put in the chat for me to clarify. And just let me know. I'm here. This is a open conversation. Of course, we're not gonna talk too much before I finish this presentation. But if you have questions or anything, then I do welcome you to put your questions in the chat, and I'll do my best to answer those questions as we go throughout this conversation. Um, Let me see. I'm going to look at that LLC question again. So I have I have property I plan to farm on. I have an LLC interested in estate planning, wondering whether to leave in the LLC or set up a trust. So I'm gonna try my best to remember to talk about that later once we actually talk about what a trust is, and that way we can put it in that context. And again, I might have pulled out my landowner presentation. I see it says most landowners would need a will. A will is something that most people are going to have as part of their estate planning. It could be the main thing that's in their estate plan, the foundation of it, or they might have a trust as the foundation of their estate plan. But even if they do have a trust, they typically will have a will that goes with it, which is called a pour over will. And that pour over will be designed to take any assets that perhaps did not get transferred into the trust and pour it over into the trust at the time of the person's death. Once their will is probated, it will pour those assets back into the trust so that the trust would manage that asset. And everything will be under one umbrella. We can talk more about that once we get into trust. So, what does a will allow you to do? It allows you to distribute your assets. You get to say who gets what. I have a house. I want to go to my oldest child, and I have a car. I want to go to my youngest child. I want my bank accounts to be split three ways. Like you get to put all of that, all of those details into your will. You get to nominate an executor. So that means you get to say who's going to be in charge of my estate, who's going to represent my estate when I'm not able to do things on my own after I pass away. They will be the one who is responsible for making sure that the terms of my will are carried out, making sure that the interests of this estate are protected, and that my beneficiaries, who are the people who are going to receive from my will, make sure that they get what I've set aside for them. Well, I think we're going to talk about that in a minute. So I'm not going to get ahead of myself. Your will can allow you to fund a trust. Like I just mentioned, you might have a trust as the main aspect of your estate plan. And you might say, just in case I forget to put something in my trust, I have this backup will that can fund my trust for me. Or you might say, I want to have a will as the foundation of my estate plan, but I know it's possible that my children may still be minors at the time of my death. So I'm going to say if they're still under the age of 21, perhaps I can say that instead of the property going to them directly, my executor is going to create a trust, and we're going to take the assets from the will and put it into we're going to take the assets that I own and put it into a trust that's set aside for this minor child, or perhaps you might have a disabled beneficiary. It can set this will can take whatever you own and have a provision in there that says, in the event that one of my beneficiaries is disabled, I want their property to go to them in this special trust. Your will can also allow you to nominate a guardian and a trustee for your minor children. So that means that you have a guardian, someone who can make legal decisions and take care of your minor children, make sure that they are getting everything that you would have been able to give them and raising them up. And then your trustee is the person who would be able to manage their money. They could be the same people or they could be different people. Some people say, I want my sister to be the guardian, I want my brother to be the trustee. That gives some checks and balances. And also, it might be that the sister is better at taking care of kids, but the brother is better at taking care of money. And in that way, you might want to split those responsibilities. And the same for a disabled beneficiary. You might say, I'm the guardian over my sister. She has special needs, and I'm her guardian. In the event that I am not able to be her guardian, I nominate my brother to be her guardian, and he will take over in taking care of my sister, or he will take over as her trustee and take care of her money on my behalf. And then finally, if you are a person who likes to give, if you're a charitable giver, you like to contribute to your favorite nonprofits or whatever that might be, your church, you can name your favorite nonprofit or your church or your school, whoever you want to name as a charitable beneficiary, you can do that through your will. So as I turn this slide, y'all let me know if y'all following me, if I'm losing y'all, like just let me know so I can make sure that I'm on the right track. When you are executing a will, there are certain requirements, and this is something that a lot of people fall into a trap when they are going online and saying, "Oh, I can create my own will." Sometimes they don't make sure that these requirements are met. Now, I will say, I know I have some people here who are not Georgia residents. These requirements are Georgia specific requirements. Your state is more than likely going to have different requirements. So you got to make sure that you know that you hire a lawyer who knows the requirements of your state. That's what I'm going to encourage y'all, hire a lawyer. I know you don't want to all the time, but it really does make a difference. I encourage you to hire a lawyer in your state who can make sure that these requirements are followed according to your state laws. In the state of Georgia, you must be over the age of 14. You must be in, I know, 14. Yeah, yeah. Because, back in the day, maybe 15-year-olds are handling business. but not so much now, but the law has not been updated. You have to be over the age of 14. You must be of sound mind. You can't be under any undue pressure, undue influence. Like if your sister is saying you need to make a will and you know you need to leave everything to me because you know that your so and so ain't gonna do right. You can't be having that going on. When that will is being signed, it must be signed in the presence by the person who's creating the will. They need to sign it in the presence of two witnesses. Those two witnesses must also sign the will in each other's presence. Everybody needs to be there together. So you can't say, I'm going to sign my will, then I'm going to take it to my neighbor over here. I'm going to get them to sign it. I'm going to take it to my other neighbor and they're going to sign it. You have to all be in the same room together, signing the will together. And also, if you have a witness sign your will and they actually are a beneficiary of your will, or they are named as the executor or the trustee, or if they're named as the executor of your will, or if they are listed as someone to receive property from your will, it could either invalidate the will to where it's not a legally valid will, or it could make it so that whatever you left to them, they will not get it. It will be as if they had died before you, because a witness has to be disinterested, someone who's not going to receive from your will. So you really need to be careful about who you choose as the witness to your will, because if they are someone who you named in your will as a beneficiary, they will miss out. And it's also possible that depending on what's going on, that your will could be invalidated. So you don't want that to happen. You also you also want to make sure that you also want to make sure in the state of Georgia, there's a self-proven affidavit. And what that does is allows you to have you as the testator, the person who's creating the will, and your two witnesses, as well as a notary, to all sign this affidavit stating that the requirements that I just went over were all met, and that no, there was nothing that was happening during that will signing process that would be something that someone would I guess get a side eye to and say that it was done improperly. Um there was one more thing I wanted to tell y'all about this. Oh, in Georgia, we have very specific things that must be on that self-proven affidavit. And one of them I did not put on this slide because I forget to do that sometimes. That it has to say that the testator, who's the person who's signing the will, as this is their will, they have to be over 14. That has to be in there. And he also needs to say that the two witnesses that signed were over the age of 18. And it needs to say things like they saw each other sign the documents and there was no undue pressure and all these things we just talked about. That self-proven affidavit has to say all of that in the state of Georgia. And if it's missing, then there's a whole process you got to go through that I have been through more times than I care to go through. But I'm just going to keep going through it because people are going to always miss. It's often the times that people are going to miss something, especially if their will was not done by a Georgia lawyer. And sometimes older wills, like if the will was done before 2020, there are things that have been changed that people didn't have on their older wills. So make sure that you have a Georgia lawyer doing your will to make sure that it's going to meet Georgia requirements. If you live in Georgia, now if you live in these other states y'all mentioned, y'all got to make sure you have a lawyer in your state, your home state. Um, Self-proven affidavit, I didn't even really tell y'all what it was, but it's something that comes with your will that most of the older wills they don't have this self-proven affidavit. But what it does is it's a way for you to um typically if you don't have a self-proven affidavit, those two witnesses that signed, they would have to come to court and say, yes, we witnessed so and so sign their will. Yes, all the things that need to be done were done properly. They will either need to come to court to do that, or you would need to track them down and have them to sign a sworn statement saying that these things happen. But as you know, it probably is the case in many cases. If the person who created the will is deceased, it's very often, well, I won't say very often, but it is sometimes the case that the witnesses are either deceased or they're well up in their years or they've moved on and you can't find them. And so it's hard to bring them into court and get them to say that they witnessed the will. So in that case, you would have that self-proven affidavit, which is an affidavit that they signed, a sworn statement that was signed along at the same time that the will was signed, saying that all of the legal requirements were met and that the witnesses were there and all those things were done, so that later when the will is actually going through probate court, you don't have to round up the witnesses and bring them into court to testify. So I just said a mouthful, but I hope it makes sense. If it didn't, y'all help me, Veronica. You got to clean that up for me. I don't understand what you just said. So I forgot to refill my water before I started this, so I'm a little parched, but I'm gonna make it through. So we just talked about wills. Now we're gonna talk about trust. This is the hot topic these days. For some reason, social media loves talking about trust and telling people all kinds of wrong information. So it's my aim to try to educate people on how trust really work and the real deal about trust. I don't proclaim to know everything, but I realize that a lot of people who don't know anything about them are going on YouTube and um, Instagram and all these different places and telling people stuff that just ain't true. So I'm gonna try my best to teach y'all the truth and tell you when you need to talk to a lawyer to get the other truth. So, what is a trust? It's not a magic tool that helps you avoid all taxes and have millions and millions of dollars for the rest of your life and the rest of your children's lives and your grandchildren's lives. Even though that's what people will have you believe on social media, it's just not the truth. It is a legal arrangement in which one person takes responsibility for property or money and manages it for the benefit of one or more other parties. And if anybody can send me an email after this thing and say, Veronica, you forgot a word, you got to put that word in there because I still forget to update it every time. A trust is a legal arrangement in which one person takes responsibility for the property or money of another person. That's the part I missed. And they manage it for the benefit of one or more other parties. And I'll have a little illustration in a minute. I also do want to clarify that you can have multiple trustees. So it's not just one person. It could be more than one trustee. And it could be more than one person whose property is being managed by this trust. Um, and as I said here, you can have one or more parties be beneficiaries to this trust. And there are many types of trusts. And I always tell people, let's not think about the name of the trust. Let's talk about what you want your trust to do, because that's going to help me determine what kind of trust I should create for you. I want to know what your goals are. We'll talk about that a little bit more, but that's going to help us determine if we should use a revocable trust or an irrevocable trust. If we need a special needs trust in there, if that special needs trust needs to be a part of your larger trust, or if it needs to be a standalone special needs trust. We can talk about if you need to create a charitable trust, if there are any benefits for you to create that. We're going to talk about if that trust should be inter vivos, which is one that you create while you are living, or if we should put provisions inside of your will or your trust that are testamentary trusts, which means that those trusts don't come into being until after you've died. So we can talk about all of that to see what's going to make the most sense for your family. And again, I don't know which presentation I pulled out for you. I thought I pulled out the most up to date, but everything is always different. So the one that I thought I had would have more information I'm going to go through now. So, as I said before, there are many types of trusts. A revocable living trust is just a name that somebody came up with. But the principles of this trust is that it's revocable, which means that you can change it during your lifetime, or if you need to just get rid of it altogether, start from scratch, you have the power to do that as long as you are alive and you are in your right mind. You're able to mentally um, engage in contracts and be able to change your trust, because a trust is really a contract. Often that trust is a contract between you and yourself. When that's a revocable trust, it'll be you as the person who created the trust. You are also the trustee, and then you might also be the beneficiary. So that's a contract with yourself and yourself. An irrevocable trust is a trust that you, as the person who established it, you, as the person who has the property that you're putting into the trust, Once you create that trust, once you transfer your property into the trust, you cannot take it back out. You cannot revoke the trust. That means you cannot change it and you cannot get rid of it. It is there. And if it is to be gotten rid of or revoked or canceled, that will have to be done by someone that is not you. So when it's irrevocable, that means you can't change it. You have put something in place that you want to be there and you don't want to be able to change it. And you don't want most people to be able to change it, but you might put one or two particular people that could change it in case it had to be changed. Because if you don't have somebody in there who could change it in case it has to be changed, if it has to be changed, someone has to go to court to get that done. So we try to make things easier for your family so that if circumstances change, something needs to be edited or revised, that they have the flexibility to do so. But the level of flexibility that they have is going to depend on your goals and what you're trying to accomplish. Some goals will require that everybody has the least amount of flexibility to change the trust. And some goals would require that you have some level of ability to change the trust because it fits in line with your goals. Um, Special needs trusts, those are trusts that are designed to set aside property for someone who has a disability. They're not able to manage their own property because of something related to them that limits their ability to do that, whether it's a mental disability or certain physical disabilities. And so a lot of times people who have disabilities or special needs, they receive public benefits, and those public benefits are going to be based, you're going to be eligible for them based on your income and your asset profile. So that means that if someone, your great aunt who loves you so much, decided she wanted to leave $100,000 to a person who has a disability and they receive SSI for their financial needs and they receive Medicaid to provide for their medical needs. This beautiful aunt who loved you so much left you this $100,000, how that has now made you disqualified for those public benefits. And although having $100,000 is nice, you have a medical condition that requires you to have health insurance because $100,000 will be spent in very quick amount of time if you don't have your health insurance. So these are the things that we are thinking about when we're planning. Because if you have a good lawyer working with you, they're gonna say, "Hey, you don't want to just leave this outright to your family member who has this maybe has severe autism. You don't want to just leave them as a beneficiary in your will or in your trust, because if you do, you're going to disqualify them from all of the benefits that have been supporting them all of this time. But if we put in a trust, they can still benefit from that asset, but they don't have control over the asset. There'll be another person who would be trustee, whose job it would be to write checks out when a check is needed and to be written out, or to make a purchase when a purchase needs to be made. And they would have to be educated on how that trust works, so they do everything in a way that's going to help that person continue their benefits. So we're going with how a trust works. So you have this trust property. It could be money, it could be real estate, it could be investment accounts, it could be options and stocks and bonds and all of those things that you can have as an asset. You have that property and you decide it does not benefit me for me to continue to own this property outright. Either I have certain liabilities that I want to protect my assets from, like I might be a doctor who does these very highly technical surgeons and people are suing me all the time. I don't want them to be able to get to the assets in my trust. So you might have this property that you want to protect or property that you want to pass to the next generation without having to go through probate court. So you get your property, your trust property. You are what will be called the grantor or the settlor or the trustor, but you're the person who is deciding that you want to get this trust created. Then you're going to have a trustee, which is the person you have designated to manage your property for your trust. As I mentioned before, if it's a revocable trust, you might be the trustee and you are also the beneficiary. You are setting this trust up to benefit yourself and you're going to be the one managing it. But then if you become incapacitated, you have a severe disability that inhibits your ability to manage your own property, or after you die, then your successor trustee would step in and do the same things that you were able to do with the property because now they're your trustee. So that's how it works. The trust is not a physical structure or like it's not like an account. A lot of times people get a trust mixed up with a trust account. Um, I'm not going to try to explain the difference because I probably am going to mess it up. But a trust may have an account. And if a trust has an account, then that account is a trust account. If the account is in the name of the trust, and almost like she sells on the seashore. The sale, I don't know how to do those tongue twisters. I get tongue twisted all the time, but basically, a trust account is not necessarily a trust. That's what I'm trying to say. A trust is just, I always say it's like a box in the air. It's a concept that owns your property for you, and your trustee takes that property that's in that box in the air and they manage it for you. And the way that we know what their responsibilities are, what they're supposed to do with the property, all the different terms, that's going to be in a trust instrument or a trust agreement. I call it a trust agreement most of the time. And the trustee's job is to maintain, manage, invest, grow, whatever it is named in that trust agreement. Their job is to do that on behalf of the beneficiaries. So I had them here happy because they get a monthly check or a quarterly check or an annual check that they don't have to work for. So the trustee's job is to work so they can benefit. Y'all tracking me? Y'all got this? It's so hard when you're on a Zoom because everybody's so quiet. Of course, y'all supposed to be quiet, but if y'all have questions, please put in chat. Or if y'all just like, we good, we understand, put that in the chat too. That kind of let me know I'm on the right track. So, let us see. I didn't have my little list. This must be my abbreviated presentation because it's all kind of slides. Next time, y'all, I'm gonna go through the slides ahead of time. But I was trying to do too much today. I actually did a live YouTube call right before this webinar, and everybody was having fun, and we were talking on that for a long time. So then I was running into this webinar. But I'm trying to do better in my life, not cram so much. But that is where we are. I am doing a daily Kwanzaa YouTube thing on my YouTube channel. It's the Family Land Lawyer. If you want to go on YouTube, search for Family Land Lawyer, then you'll see where we have our live Kwanzaa conversation every day for the rest of Kwanzaa. Today was Ujima. Tomorrow is Ujama or Ujama, depending on the right way to say it. And I talked through each of the principles of Kwanzaa each day. So that's going to be tomorrow at 11 a.m. Eastern. I've been doing that for the past couple of days, and I will continue doing it until Kwanzaa is over. And we'll see what happens after that. Anyway, I thank y'all so much for tuning in here tonight. Let us see. Okay, everybody say they understand it. I'm so happy to hear that. What happens if you die without an estate plan? So this is like, this skipped a whole lot. So I'm going to try to fill in the blanks where I can. We talked about a will. We talked about a trust. We talked about an advance directive for healthcare very briefly. We touched on it. We said that that is where you get to name someone who's over your medical decisions, and you also get to say some of the medical decisions you want made, and that's where you make your end of life choices. If I am unable to take medications by mouth, do I want to have like the intravenous medications? Do I want a feeding tube? Do I want a ventilator, all those things? You get to put those instructions in your advanced directive for healthcare. Or you can say, I just want so and so to be my agent and they make all the decisions for me. You also can have your financial power of attorney where you name an agent who will be over your finances. They make legal decisions for you. They can manage your money for you, and you can state what powers you want to give your financial power of attorney in that power of attorney document. I said I was going to talk about the LLC situation a little bit. So if you own real estate, An LLC can be a great tool to put your real estate into. Now, I will caution you, if you own residential real estate, you may not want to put that in an LLC because then you will miss out on homestead exemption. So if you have a homestead exemption or a senior exemption or whatever other types of tax exemptions that your local government may offer you, putting that property into an LLC will turn it into more of a commercial. They'll see it as a commercial or investment property, and you won't be qualifying for those exemptions, at least in the state of Georgia. I don't know about other states. But if you own real estate that's not your personal residential real estate, you might want to put it into an LLC. And that LLC is going to protect that property from your personal liabilities, and it also protects your personal assets from those liabilities that may come from that asset. So let's say that you own rental properties and you have tenants and somebody gets hurt and they sue you. If your property's in the LLC, they should be suing you as the LLC, not suing you as your personal name. It insulates you personally from your liabilities that may arise from your business ventures or other ventures, investment opportunities, things like that. So you can put your property into an LLC, a limited liability company, and then if you have a trust, you can take the ownership of your limited liability company and assign it to your trust. So instead of you owning your limited liability company, instead of you being a member of it in your own name, you would be a member as a trustee of your trust, or whoever your trustee is, they would be the member of your LLC. And that means they would have the voting rights and the powers and things like that to manage that LLC according to the terms of your operating agreement. It's very important that you have a strong operating agreement that tells you and tells the world, this is how my LLC operates, this is who is in charge, this is who can make decisions. So the question of should I put my property into an LLC or a trust, if it's some commercial property or investment property, anything other than your personal residential property, you might consider putting it into an LLC. And if you're going to have a trust as the foundation of your estate plan, then you want to assign your LLC to your trust. The same for your business. Like you could be a business owner, no real estate owned or anything like that, but you still might want your trust to own your business instead of you being the direct owner. Um, as y'all can see, this is not just like ABC 1, 2, 3 stuff. This is like complex. Let's think through it. Let's see what's gonna be good. What are the pros and cons of different decisions? So I do strongly advise you to talk to a lawyer licensed in your state who is familiar with all of these different issues and can advise you on what's going to be the best route for you and your family. So, with that being said, what happens if you die without this type of plan in place? Your property is going to be distributed to your heirs at law, which is determined to state law. So, if you die without a will or you die without a trust, whatever it is that you own is going to be distributed to your heirs at law. Here in the state of Georgia, your heirs at law are your surviving spouse and your surviving children. If you don't have a spouse but you have children, then those are your heirs. They split it equally. If you have children, if you have a spouse but no children, your only heir will be your spouse. If you don't have a spouse, you don't have children at the time of your death. If you had children and they've died, then their children will be your heirs, your grandchildren. If you don't have grandchildren, they're going to look at your parents. Are your parents still living? If they are, one or both of them would be your heirs. If your parents are not living, we're going to look at grandparents. If they're not there, we're going to go to brothers and sisters, then nieces and nephews. Then it just goes on and on. I've had estates where the only heir was first cousins. I had an estate where the only heirs was a first cousin once removed and then like several second cousins. If you have any kind of family, they will be your heirs. It's just a matter of determining who is going to be. And that's going to be determined by your state law. If you don't know what your state law is, then you just going to be up to the discretion of whatever your state law is. That's what happens to your property after you die. It goes to those people, wherever they are. We don't know. Do it make sense? We don't know. It may make sense, it may not make sense. Would it make sense for you and you bought a house with your spouse, you die, you have your spouse and you have your three children from a previous marriage. Your spouse and your three children from your previous marriage will inherit your house. Even though your spouse owns half, your estate is going to own the other half, which includes your surviving spouse and your children from the other marriage. And I don't know if I had to say anything else to say that that's not often a great setup, because the children from the other marriage may not want your spouse to get what they're legally entitled to. And they certainly not going to want them to get more than what they're legally entitled to. And I've seen situations where this kind of breakdown has caused a lot of problems for families. But I've also seen it even where this kind of situation has caused problems for families when these are your children. The surviving spouse is sharing property with their own children, and their own children are not in agreement with whatever that surviving spouse is wanting. So that's what happens when we die without a will. I spent a lot of time on that one, but a judge would determine who's going to administer your estate. If you have a will or if you have a trust, you get to name who's in charge. If you don't have a will or a trust, a judge is going to decide who's in charge, and they're going to appoint someone who administers your estate. It may or may not be the person who's the best fit for that role. It's just going to be whoever is presenting themselves before the judge is the person who should serve in that role. And a lot of times when families fight over this, then the judge is going to appoint a court appointed county administrator, someone who's not related to your family, a lawyer whose job it is to handle the estates of unrepresented estates. And more than likely, you don't want that to happen because they want to get paid. And the way they get paid is by selling everything you own, taking their percentage, paying the fees, and splitting the rest between your children or your heirs, whoever they are. You don't want that. If you have minor children, then the judge is going to decide who takes custody of them. And if you have property that you're leaving to them, they're going to decide who's going to be over the money that you left to them or the assets that you left to them. So I encourage everybody to create some form of an estate plan, because an estate plan keeps you in the driver's seat. Instead of you being your family being at the whims of state law, then you get to decide in advance how things will go. You take the burden off your family, and it helps you to be the one to decide how your property is going to be distributed. That helps you to maximize the value of the assets you pass on, and allows you to leave a legacy that outlives you. And what I also want to add that I think a lot of people don't realize is, if you are alive and you become incapacitated, let's say you have a stroke or you get into an accident or you have some other kind of degenerative disease, and you are no longer able to manage your own affairs, in order to have someone who can get legal responsibility over your affairs, because you're a grown person, your family will have to go to court and get the court to appoint a guardian and or a conservator of your estate. That process requires the involvement of your family filing that petition, them getting another family member or person to agree to that you need a guardian or a conservator, or you got to get a doctor involved in the process. It's going to require hiring lots of lawyers, because if the family filing the petition to become guardian or conservator, they might need a lawyer. And then the court's going to appoint a guardian ad litem, who is a lawyer whose job it is to make sure that the needs of the person who's going to be under this guardianship are protected. And then also they're going to they're going to have a lawyer who represents the interest of the person who represents their stated wishes. So it's basically like the person's going to have two lawyers representing their interests. All of these folks got to get paid. So you can imagine how expensive that process is and how much time it is and how stressful it can be. But if you have a power of attorney in place and an advance directive in place, then you get to put someone in place who can take on those responsibilities without the courts having to get involved. All right, slides. So now we'll talk about how you create an estate plan. I got 5 minutes left. I'm gonna do what I can in these 5 minutes. But if you want to stay over a little bit, I will do my best to get close to finishing up. I encourage my clients to view estate planning as a gift, not a burden, not something that I dread doing, but something that's a gift. And GIFT stands for goals, inventory, fiduciaries, and team of advisors. So establish your goals, create an inventory, select fiduciaries, assemble your advisors. That's how I guide clients through the process. With establishing your goals, I say begin with the end in mind. That's what we talked about at the beginning. Where do you want things to be at the end of your life? And you are creating a plan to get things to that point. You want to cast that vision so that the people you leave behind can pick up the torch where you leave off and keep running. You want to talk about who you want to receive your assets. What do you want them to receive? When do you want them to receive it? And what method do you want them to receive? What means do you want them to receive it? Creating an inventory. That's listing out all the things you own, whether it's real property, cash, bank accounts, investment accounts, farm equipment. If you're a farmer, I work with a lot of farmers. Business assets that you may have, personal property, vehicles, all those things. Make a list of what you own because you might be surprised and realize that you own more than you thought. And it might be worth a lot more than you thought it was worth, but you just never sat down and added it all up. You might be surprised. And a lot of times people end up finding accounts that they forgot about and they have to start consolidating things and putting everything in a single account because they had little accounts here and there that they had to now account for. Select your fiduciaries. Fiduciaries are individuals that you name to be the directors of your estate plan in a sense. So your executor for your will. If you have a trust, it's going to be your trustees, legal guardians for minor children, legal guardian or conservator in case you become incapacitated, your agents, your power of attorney, your healthcare agents. All of those different people, you want to think through who's going to be the best person to serve in those roles. It may be that the same person will serve in all of those roles, or it might be that you mix it up a little bit based on what everybody's strengths are, who you trust to do what, or sometimes you might split up the roles so that one person's not bearing the whole responsibility for taking care of things. And then you want to assemble your team of advisors. Depending on your personal situation, you may need to involve financial advisors, insurance agents, land use experts, business consultants. Depends on what you have going on. I didn't say you may need to involve attorneys because I'm strongly encouraging and advising that you involve an attorney at the least. But if you have special things going on, you need these other folks too in order to create a comprehensive estate plan that's really going to meet your family's needs. And when you're selecting an attorney, I encourage you to select an estate planning attorney. And because there's lots of attorneys, and there are a lot of attorneys who will do a will for you as part of their divorce services or their criminal services or their business planning services. They'll do a will, but they may not have the expertise to create a comprehensive estate plan that addresses all the things we just talked about, particularly things like retirement benefits. How do you plan for those? Family members with special needs, if you have long term care planning needs, if you believe you might need to go to a nursing home at some point, do you have a plan to make sure that your family can afford it, to make sure you can afford it? If you have family land or you have a business, you're going to need special succession planning to make sure those things are accounted for. Heirs property is a special thing that might need to be accounted for. And you want to choose someone that you feel comfortable with and who understands and appreciates your personal, familial, and cultural values. There are a lot of people who go to a lawyer because they're just looking for a lawyer, and that lawyer may not know where they're coming from. They may not understand some of the values that they have. And so they create a one size fits all plan for them, and it's not one that actually fits them. And so you want to choose someone who you know is going to know where you're coming from and help you create a plan that aligns with where you're trying to go. And I encourage people to be creative with their estate planning. It may be that if you have property and you're trying to figure out how to address splitting property between heirs versus bank accounts, you want to be creative in the ways that you structure things so that you can accomplish the goals that your family has and the goals that you have. I thank you so much for your feedback on the presentation. Let me know this has been helpful. All right. So when you are estate planning, there are some pitfalls I want everybody to avoid. I want to make sure that you don't unintentionally create heirs property. So I think I told y'all at the beginning that I specialize in working with families on heirs property, and I don't want you to unintentionally create more heirs property by saying, I leave my property to all my kids and my nieces and nephews, and y'all share and share alike and have a blessed day. Because you've just created heirs property. Or even if you say, I want all my kids to get my house, and you don't put anything in place that helps decide who gets to decide what happens to the house. You just got four people who are grown, all having to decide what happens to this house. You don't want to create that situation for your family. Another pitfall is not planning for medical or long-term care expenses. Medicaid estate recovery. Some people will create these beautiful estate plans, and then at the time of their death, they had spent time in a nursing home, and the state ends up taking everything that they had because they had this big nursing home bill. These are things that can be avoided with proper planning, but a lot of times people are not planning for these things. Um, it's expensive to get old. I'm learning that. I'm not there yet personally, but family members, I'm realizing that just to keep people alive once they're not working anymore, it can be pretty expensive. So we know this is happening, y'all. Like it's not a surprise. Go online and Google nursing home expenses, Google long-term care expenses. It's expensive. We got to have a plan, y'all, because it's expensive. I'm speaking from experience. It costs a lot of money to take care of people when they get sick or they become disabled. And so we have to have a plan in place to take that burden off of our family. You want to avoid tax issues, the state income tax, gift and tax, retirement benefits, all that stuff. And you don't have to worry about any of that because if you hire the right professionals, you don't have to plan for those things yourself. Your professional can make sure those things are in place for you. So, what is next? What is next is if you are interested in working with me, working with my firm to help you with estate planning, this is what we do. We love working with families on their estate planning. So you can just scan that QR code and that will take you to a link where you can schedule a call with me. We'll talk briefly about your goals and what you want to accomplish with estate planning and talk with you about what plan we recommend for you, what the pricing would be, all of those details. We are a law firm that specializes in estate planning. We specialize in helping families with heirs property. We don't just do quick wills and just like something to put something in place. We help people with comprehensive planning. So if that's something that you are interested in, I encourage you to scan the QR code, schedule an appointment with me. This consultation, because you attended this webinar, there is no cost for it. So you can schedule it. Now, if you're not serious about doing estate planning, then please don't schedule this. There are other opportunities to hear from me. Like I said, I have the YouTube channel. It's called The Family Land Lawyer. We are on YouTube. Right now, we're doing a daily call at 11 where I'm just talking about heirs property in the context of Kwanzaa. And I will be doing much more. So if you just want to hang out with me, we can do that. But if you are interested in getting started on your estate planning, you can scan this QR code. If you already have talked to me about estate planning and it's just a matter of us like getting everything in place for you to get it done, then we'll follow up with you on that. You don't have to do this. Scan this QR code. You can email us and just say, hey, I hadn't heard. I'm ready to get started, whatever you need to do. But if you are new to working with us, you can scan this QR code and then that'll help you to get connected with me. Yes, I do only work with clients in Georgia when it comes to estate planning. Well, most stuff because I'm licensed in Georgia. I can help families who own heirs property, particularly if the property is in Georgia, regardless of where they live. But I am potentially working with families with heirs property to just kind of educate and consult to support them in the journey of working on their family heirs property, but not necessarily providing legal representation. So that is a way that I am working with people outside of Georgia. But when it comes to estate planning and things like that, I do work specifically with Georgia clients. But if there is someone here who does not live in Georgia and they need estate planning, let me know where you're from, and I might be able to connect you with a colleague who I would trust to do a great job in that state. So I do have people all over the country, not everywhere, but in various places. So if there's someone who needs an attorney in their states, let me know, and I will try to connect you with someone. So I am going to stop my share. I appreciate y'all for tuning in and for hanging out for the rest of this entire call. Someone asked if I have property in Georgia but live in Alabama, then yeah, we can help you with the Georgia property. So if it's estate planning, we probably would need to connect with an attorney in your home state. But I have an amazing colleague and some amazing colleagues in Alabama that I would connect to, and we can help with the Georgia side. We got somebody in North Carolina. I got some amazing colleagues in North Carolina, so we can help put you in touch with someone who can help in North Carolina, Alabama. I need somebody in Mississippi. So if y'all know somebody in Mississippi, let me know. I am potentially considering getting licensed or hiring somebody or something in Mississippi because I get a lot of calls from Mississippi, but I just don't know anybody that I trust there. But I do know people in other places. So just let me know. Again, I really appreciate y'all being here and for your attentiveness, your questions. If anybody had any questions, I would be happy to answer a couple of them before we close up. But otherwise, we are done here. And I can, if there are no questions, then we will go ahead.